What I want to do now is check out a clip from the Perry Mason Show, which is now in season 2 on HBO. For those that don't know, this was a reboot of a show from yesteryear, and it takes place more or less in the 1920s. What we're going to see here is courtroom drama play out where Perry Mason's representing the plaintiff, a grocery store owner, bringing a civil cause of action against basically a former employee who got disgruntled, left, and started a competing business.
All rise.
You may be seated.
Sorry. Why are you moving?
I'm not.
Mr. Bertel, exactly how many years did you work at Sunny Martin?
I mean, just as a matter of professionalism and decorum, rarely are you going to walk into trial after the judges took the bench and not say anything, including like, sorry, Your Honor, or have the judge inquire on you. I don't know why they skipped that, maybe just for the sake of editing, but they wouldn't be coming in having a conversation interrupting the proceedings after the judge took the bench.
7 years. 3 of those as a manager.
And how would you say the owner, Mr. Grice, treated you?
He was a tough boss.
Did your pay increase very much when you became manager?
Barely.
And yet you're the one who helped design the layout of Mr. Grice's stores, isn't that right?
That's right.
And since then, the stores have seen an increase in sales of a...
So this is the defendant's own lawyer putting his client on the stand. So this would be a direct examination where typically only open-ended questions are permitted. What you just saw here at the end was a leading question. It was close-ended, meaning it was almost a conclusion being said as a question. That's why he ended it, isn't that correct? You see that a lot in TV and movies. It is technically objectionable. It's up to the other attorney that whether or not strategically they want to interrupt the proceedings for that.
Staggering 60%, even in these times. But did Mr. Grice ever give you credit for your design? Did he compensate you in any way?
No.
So this is, a direct examination is not a closing argument. It's not even an opening statement, meaning it's not an opportunity for the attorney who's asking their own client, now a witness, questions, to be lecturing, to be giving a speech and pontificating. Here he's basically trying to inject facts, testify himself. He's looking in the gallery. There's a lot of drama here. Not all of it is improper, but I think that the thrust of it is, especially when he's tossing out statistics, numbers, and he's putting a whole bunch of facts together, that would make the question compound and I think objectionable.
And no.
Did you talk to him about it?
I did. And he told me if I didn't like it, I could take it on the arches.
And that's exactly what you did. And what did you do next?
I opened up my own store.
You opened your own store, pursued your dream, followed the natural progression of God-given capitalism and industriousness that makes this country great.
Is there a question in there, Your Honor? Does Mr. Keller intend to give all his client's testimony himself?
Yes, this is, can you pause it? This is right on cue. Perry's right on cue with this. This is not a question. It's counsel testifying. He's trying to give a closing argument when he should be just asking his client questions. And Perry was right on the nose with a contemporaneous objection.
Mr. Keller, if you could limit yourself to actual questions.
Of course, Your Honor. It's just difficult when I'm so proud to be representing this fine man.
Far be it for me to get between two men in love, but that also didn't sound like a question.
Injecting humor, I mean, look, courtrooms are pretty stilted and stoic at times, but humor is not always inappropriate. I think what makes it inappropriate here is he's commenting openly in front of the jury. But actually what the defense lawyer did, the one who was being objected to, even in responding to the court, he should have just kept moving along and asking questions. Instead, he tried to ingratiate himself further with the jury by talking about how proud I am. None of that stuff is admissible. It's not proper, and the court would not have liked that in real life.
And that's not a proper objection, Mr. Mason. Mr. Keller, you may proceed with your questioning.
Why are you here today, Mr. Pertel?
Because Sonny Grice is saying I stole his ideas for my store.
But you didn't steal anything, did you?
How could I? They were my ideas to begin with.
Your ideas, your methods, your designs that Sonny Grice benefited greatly from and is now claiming are his and suing you in the process.
He wants to put all of the competition out of business.
Objection. Sorry. He can't testify to what our client wants.
I got this. Objection. Your Honor, Mr. Pertel has no idea what my client wants and does not want.
Sustained.
So the nature of the objection really sounds like he's calling for speculation, which would be a real objection. What's bizarre in this scene is that's the paralegal making the objection. The paralegal never sits at the counsel table, and they don't speak in open court, especially during trial. They definitely don't lodge objections. If the judge was aware that this was a paralegal, I don't think that she would be permitted to sit at counsel table, and there might have been a big issue there about unauthorized practice of law. I think the way that Perry handled it, though, was very calming, disarming, and the court obviously let it pass. The reason we even say lawyers have to pass the bar is, historically, that little wall that separates the gallery of a courtroom from up front where counsel table is, the bench, or the witness stands, that's called the bar. And in old times, they used to say you weren't eligible to walk through that little door and go past the bar until you became a lawyer, and that's where it comes from. So the paralegal probably wouldn't be sitting there anyway.
Mr. Patel, do you feel that Sonny Grice wants to put you out of business?
Yes. I feel he wants to crush me.
No further questions?
What are you doing?
I want to try something.
We need to talk about this. We need to establish.
You know what I love, Ed? Quaker crackle cereal. I mostly eat them right out of the box, like popcorn.
He called the witness by his first name, no matter how informal you want to be, even if it's to be persuasive to the jury. I've had judges really get upset about that and ask people to use surnames only. The other thing is reaching into your briefcase and pulling out what amounts to be an exhibit. In this case, it looks like a cereal box. If that wasn't pre-marked as an exhibit with the clerk in real life, that would be a big no-no. In fact, we once had a case where a defense lawyer was pulling, there it was documents, but pulling documents out of his briefcase, showing them to the jury. You know, there were objections, the judge sustained them, they were made court exhibits. It's a big no-no. In real life, exhibits are exchanged before trial, and the clerk is the one that possesses them during trial. So if you want to show the witness anything that is an exhibit or evidence, you're going to have to get it from the clerk first.
I've even taken this to the movie theater. Where would I find that in your store? Which aisle? I've taken this to the movie theater.
6.
Where would I find that in your Interesting. It's the same as Sonny's. I'm also a big devotee. Underwood deviled ham. That makes a good sandwich. Where would I find that?
Aisle 12.
I'm also a big devotee. Again. And what about the bromo? But when the crackles on aisle 6 and the ham on aisle 12 come back up.
Aisle 2.
And what about the bromo? Just like
Can you stop for a second?
Well, that's 3 for 3. Just like Sonny. That's a batting average Lou Gehrig would be jealous of.
I think what you see here is an attempt at some really effective advocacy, and I don't think it's by accident. I think it's pretty clear that the show has some legal consultants, because unlike a lot of courtroom drama, TVs, and movies, this one's a lot closer to real life than not. What you see here is Perry trying to simultaneously extract information from a witness, but really just use the witness as a conduit for what he wants to share with the jury, and he gets a lot more flexibility to do that on cross-examination, where the presumption is, for good advocates, you're asking leading questions, or those that sound like a conclusion, but they're really questions. I think where he might go over the line, but he's not being objected to, so I think he can continue to do it, is he's injecting evidence that's not yet there. For example, there is no evidence that we're aware of yet that the same products are in the same aisles in Sonny's. That would be a follow-up question he would likely ask the witness. So, for example, witness, I found this in your store, what aisle? 6. Where would you find this at Sonny's? You used to work there. 6. Witness, I found this in aisle 2 in your store. Where would you find this at Sonny's? Aisle 2. Like, get the actual evidence from the witness stand, because there's always an instruction in the law that what the lawyers say is not evidence. And although it may sound good, may feel good, and you may feel like you're making headway with the jury, ultimately, if they hear that admonition, they're not supposed to listen to it.
Mr. Pertel, do you think Henry Ford pays his engineers to invent devices for his company and then expects them to go down the street and reinvent them for themselves to sell?
No, it's not like that, Mr. Mason. If you knew anything about markets, you would know that those were just logical places. Any market would put those items. That has nothing to do with what Sonny Grice taught me.
What's the slogan for Sonny Market?
All under one roof.
And for your store?
Everything under our roof.
Oh, thank you for changing those few letters.
Your Honor.
Because I came up with the one for Sonny's.
While you're an employee at Mr. Grice's store, you were compensated for everything you did with the understanding that you were doing it for Sunny Market.
Objection. Now it's Mr. Mason who is testifying.
Sustained.
Mr. Patel, can you recognize in this photograph where and what this is?
Yes, that's my office in my store. How do you have that?
If you look at this enlarged photograph, can you read the title on the spine of the binder?
I didn't steal from him.
Actually, that's not the title. The title is Sunny Market, Manager's Handbook. Your Honor, I'd like to submit this into evidence, Exhibit D.
I have that because I wrote it. I wrote it!
And you were paid for it by a man who expected you to be loyal enough not to steal it for your own purposes.
So the original Perry Mason and now carrying forward into this reboot, this was always the thing. Perry would always catch someone on the stand, get them to admit to lying or having some motive or bias. That's what makes it good TV to watch. But in this instance, as a lawyer, what makes it problematic for me is, again, he's pulling photographs that the presumption is he hasn't shown the other side because the witness has never seen him and he's a party to the lawsuit, which means they're probably never disclosed as exhibits, probably never listed, and maybe inadmissible. There's nothing necessarily that... There's nothing inherently that makes surveillance, like going and doing your own footwork investigation and taking photos, improper, but you got to follow the rules of procedure, including discovery and disclosing the exhibits you intend to use at trial. Here he clearly didn't, but obviously it's for dramatic effect.
No further questions, Your Honor.
No, that's not it. Those are my ideas. He stole from me. He stole from me. Can you see that? He's trying to ruin me. This isn't fair. How did you get in my office
Mr.
anyway?
Patel.
This isn't right.
Mr. Patel, you may step down.
The witness would never be allowed to ramble like this. Frankly, his lawyer should be stepping up and saying that's enough. The court would also be saying there's no question, please stop. You're excused from the stand, go find your way back to counsel table. But obviously it makes for better TV this way.
This isn't fair. How did you get in my office anyway?
Patel.
This isn't right.
Mr. Patel, you may step down.
There's the admonition. I think what you hear there, though, that does raise a red flag ethically is it sounds like this witness is basically saying Perry must have hired someone or gone himself into a private location that was not available to the public without permission. That's a problem. In most states, if you want, you can get permission to go to the defendant's property and perform a site inspection, even review records. You can request that records be produced, but what you can't do is do it surreptitiously without them knowing, especially when it's private property.
Fresh from E.
We did a full audit. But we worked out a payment schedule to get your money in full.
You know who settles? People who know they're going to lose. People who lost their nerve. A moment like that, you can break a man. I think I just heard Ed Patel crack wide open.
There's really no need to break him any further.
I mean, the man did work for you for many years.
Were you in the war, Mason?
Delicious frozen confections, all under one roof.
Yes,
Come
France.
down to our
So you and I both know
100-store
firsthand. Mercy's not something people can
when you
afford.
check out,
It's
you
a
two will be
supermarket.
singing.
Not the Battle of the Marne. This is a good deal.
Not to me, it's not. I'm fighting for my life. And I need fighters by my side. No, I thought you were that man. But maybe I was wrong, because fighters kill. You don't seem to have it in you to finish a job. You have to find another fighter? What do you got?
No, I can finish the job.
Change the store's
Good.
layout, give you approval over it, and drop it.
All right,
Ladies,
pause.
we also negotiated a settlement of $5,000 for damages and infringement.
$5,000?
Mr. Patel doesn't even have that right now. We did a full audit, but we worked out a payment schedule to get your money in full.
You know who settles? People who know they're gonna lose. People who lost their nerve. At a moment like that, you can break a man. I think I just heard Ed Patel crack wide open.
There's really no need to break him any further.
I mean, the man did work for you for many years.
Were you in the war, Mason?
Yes, France.
So then you and I both know firsthand. Mercy's not something people can afford when they're in a war.
It's a supermarket. Not the Battle of the Marne. This is a good deal.
Not to me, it's not. I'm fighting for my life, and I need fighters by my side. Now, I thought you were that man, but maybe I was wrong, because fighters kill. You don't seem to have it in you to finish a job. Do I have to find another fighter?
No, I can finish the job.
Good.
Ladies, back to work.
What you see here is an attorney and a paralegal counseling the client as to a proposed settlement agreement. And it sounds like basically in exchange for $500, which would compensate Sonny and guarantee he gets the money because they worked out a payment plan, he could let this thing go and avoid the stress of ongoing litigation and frankly the risk of an unknown verdict. Here, Sonny, and it happens from sometimes, the client gets unreasonable, they see dollar signs in their eyes. Here it sounds like almost more vindictive, like a vendetta and revenge, which is not really something that should be coming into the consciousness, but we're all human. But even though I've never had this conversation where, hey, they're begging us to take this settlement offer, and if we don't, it could ruin them, and we should feel sympathy for them, that's not realistic because we're typically going up against enormous insurance companies. What is realistic is that from time to time we give advice to clients about what we think the risk of a case is, what the outcome might be, what we think fair value is, but ultimately the client is in the driver's seat. They are the ones that control whether or not to accept, reject, or even make or take a settlement offer.
Grice versus Pertel, find in favor of the plaintiff, Sonny Grice. It is the judgment of this court to award Mr. Grice the full amount of $50,000.
May I speak, Your Honor?
Counsel?
Mr. Pertel doesn't have the financial means to pay anything even close to that amount. His net assets are less than $500. He couldn't pay Mr. Grice in a lifetime.
You're absolutely sure? Your Honor, my client isn't unsympathetic to Mr. Pertel's plight. He certainly doesn't want to see the defendant ruined by this enormous debt. And so, Mr. Grice is generously offering to forego the debt owed to him in exchange for Mr. Pertel signing over his store to Mr. Grice.
Mr. Kellard.
So what you saw in the beginning of this scene is publishing a verdict, and it's more common that the clerk of court would read it, but judges are allowed to do it too. What it seems like is the jury decided only liability, meaning should the plaintiff prevail, was the defendant at fault. But then it said it's the judgment of this court that the amount will be $15,000. He almost read that like it was a criminal sentence. He read it as if it was the judge deciding the amount of damages, which is uncommon. It should have been up for the jury to decide what was fair for the case. Now, putting all of that aside, the jury would have been excused. You wouldn't have all of this back and forth in the presence of a jury. And frankly, you wouldn't really have this back and forth in front of the judge. The financial wherewithal of the parties is something that is well known in all jurisdictions to be completely irrelevant. That's the nature of lawsuits. Somebody's got a claim and wants money and compensation. The other side is going to either defend it or settle out. And when they roll the dice and they go to trial and lose, whatever the judgment is, they're on the hook for. Now, you rarely, if ever, involve the court in any communications related to settlement, and you're definitely not going to do it right after a jury verdict and say, hey, judge, this is what my client's willing to do. It just doesn't happen like that. More realistically would be more realistically would be the jury verdict is published, the jury is excused, the parties leave the courtroom, a judgment is entered for $15,000, and then the lawyers can talk with each other about how one side is going to fulfill their obligations, and you can settle a case after a verdict. That's not unrealistic at all. You can settle it forever you want. The clients are in control, but you wouldn't be doing it in the courthouse, and you wouldn't be doing it in this manner. So if I were to grade this episode from season 2 of Perry Mason, I would give it a B+ for terms of how accurate it really is. I think they clearly had legal consultants, and a lot of the things that happen in the courtroom are far more realistic than not. Perry Mason in particular, I'd obviously give an A+. He got the witness to crack on the stand, he had some surprise evidence, he gets this miraculous verdict, and then within a couple of seconds he's able to convince the defendant to basically fork over everything he's got to the benefit of his client, even though he clearly wrestles with the outcome of that. So he's obviously an effective lawyer. If you like content like this, drop a comment below, hit the like button, reshare it. We always want feedback, and hopefully you'll stay tuned for another installation just like this.